Willem has worn many hats in the past, working as a judge, as a counselor at the Court of Appeal in Belgium, and he was also president of the Belgian Data Protection Authority, DPA, for 14 years. And he was one of the first vice chairs of the EDPB in its early days. He was also president of the Flemish League of Human Rights in the 80s, and currently is working as a guest professor at the University of Ghent, and is also a member of the board of the Belgian Federal Institution for the Defense of Human Rights. So he will speak from a wealth of experience, and he is also one of the protagonists in the Belgian Facebook case, which is prominently featuring on our panel today. Next, we have Herwig, Professor Herwig Hofmann of the University of Luxembourg, who has also published and studied extensively transnational public law, European administrative law and procedure, who is one of the, I believe, project coordinators of the Renewal and Renewal 2.0 projects, which were already referenced by some speakers earlier today and yesterday as potential sources of inspiration for future harmonization efforts at EU level. And he also, next to his academic work, represented argued cases before the Court of Justice, including the 3 cases with Max Schrems. We also have with us Eva Gromnicka, who herself has several years of experience of arguing various cases before the Court of Justice, first as the representative of the Polish government for many years, and most recently she moved to the EFTA Surveillance Authority, where she also has the pleasure of arguing cases, including on data protection, before the EFTA court, but also appearing before the Court of Justice and even the Court of Human Rights. And finally, Herke Kranenborg, who those who have been touring this data protection circuit the longest might remember as an EDPS head of legal at the time. Now he is a member of the European Commission Legal Service, dealing with data protection since several years. So obviously knows best what is going on and what has been going on at the Court of Justice from his own experience. And I propose that we start, Herke, with you. But before I give you the floor, just to give you a little bit of a flavor what we are going to talk about today. So indeed, in the description of the panel, we referenced this one particular case that has already been mentioned in several discussions and presentations over the course of the past 2 days, the Belgian Facebook case, or Facebook Belgium case. That is the one that the court decided in relation to the one-stop shop procedure. But we will, of course, not focus or not be discussing exclusively this one, because there is too much excitement and too many other relevant developments at the courts that are going on right now. So we will give you a broader overview of the cases which are currently pending. Maybe not all of them, because we would not be able to do that in this 1 hour, but to be able to find some trends there. We will also try to point out to you some additional complexities to what was already discussed about how the one-stop shop and GDPR enforcement more broadly functions in relation to the role and the place of the EEA member countries. And then on the basis of the Court of Justice case law that we have so far and our expectations for the near future, we will try to draw some lessons and conclusions. So with this, Herke, I would ask you to kick off by giving us some insights into what the court has been up to, also building on your close involvement in both past and pending data protection cases at the Court of Justice.
Thank you very much, Anna. Of course, I feel very honored to be able to participate in this panel. And I must say this conference is really a joy, and it's super well organized, and I'm inspired by every session I've attended so far. So I understood I have 5 minutes to discuss 55 pending cases in the Court of Justice at the moment, which gives me about 5 seconds per case, and then I can have some closing remarks in 20 seconds. I'm afraid I will not be able to do so. What I will do, so very briefly, is just give some general indications of the case law, and then say what kind of themes indeed are currently at issue. So we are talking about 55 data protection related cases at the Court of Justice which are pending. By the way, 2 of them, or perhaps you could even say 5 of them, will be decided next week. So on Tuesday there will be the case on the EU PNR directive, the validity of the EU PNR directive. And on Wednesday there will be a case in the case Maastricht, which will be about German law which puts additional requirements to the firing of a data protection officer. So that one is very, well, they are both very relevant. But on the EU PNR there are a couple of cases relating to the validity of the PNR directive, so, you know, the 55 will go down quite quickly next week. But if we look at those 55 cases, there are a few striking things. So first of all, 24 of those, well, they are all preliminary rulings. I'm not talking about, there are also some pending actions before the General Court, for instance, the WhatsApp case, but I will not talk about those. I'm purely talking about the Court of Justice at highest instance. So out of those 55, there are 24 from one member state. Anyone an idea? Ireland. Ah, you would think so. No, that's more for the direct actions, I would say. Germany. So there are 24 from Germany, 5 from Austria, which makes more than half German, German language, sorry. There are 7 from Bulgaria, in particular on the Law Enforcement Directive. And I was sitting next to the director of the Bulgarian Data Protection Authority. And he explained a bit those cases and where they come from. And then there are 2, 3, 1 per several member states. So a large majority comes from Germany. And then the obvious thing is to think that that's because Germany the roots of data protection come from Germany, very concerned about data protection. Yes, that's true. And of course, several cases are precisely about that. But my feeling is that Germany also has a bit of a problem with how to deal with this regulation on data protection, which is having, of course, direct effect in the national legal order. How does that relate to existing laws they have in place? At the time of negotiating the GDPR, they made some tweaks in the GDPR, which could be hooks to say that those legislations could remain in place, but is that truly the case? And those are the kind of questions which come to the Court of Justice. Also, how does it interfere or relate to national procedural law, which is precisely a theme which we have been discussing over the last 2 days. So it's not only because of the big data protection tradition in Germany. 31 cases are about the GDPR, 10 about the privacy directive, all about data retention, but all kind of twists about data retention. It's not all the same. 6 about the law enforcement directive, and 8 are on validity of EU law as such. So that's tested against the charter. EU PNR is one example, but you also have the beneficial ownership register, and there is more recently the union law which prescribes to have fingerprints in ID documents, so not so the identity documents. So I'm already close to the 5 minutes now. But what in general do we see in trends? I can say the general subjects. So first of all, there are many cases about national law. Is the national law in conformity with the GDPR? The GDPR, as we all know, leaves quite some room for national law. But there are quite some questions about this. Okay, and it actually leads to the Court of Justice having to assess proportionality of national legislation, which is not necessarily on a subject which is naturally within the competence of the European Union. There's Advocate General Spooner once said that it seems that data protection has become a policy area in its own right in the European Union. Then there are cases about grounds for processing. A big one is, of course, one also instigated by Schrems in the beginning, about whether the Facebook terms and conditions are based on consent or on a contract. That one has been suspended because the same question on substance also occurs in another very important case, which is the famous case also about, Facebook, where there is the collision between the Bundeskartellamt, the German competition authority, and how it relates to the competence of the Data Protection Authority. You have the one-stop shop mechanism which is applicable. What can a competition law authority then do actually? Because yesterday Mrs. Verstager has spoken about synergies, cooperation. That's all fine. Of course, all support of that, and that is the solution. But what if it doesn't function like that? What if there is no cooperation? And then it becomes, of course, a question of law. Who is right there? On rights, we have from small things, what is a copy of personal data, super relevant in practice, to are you entitled to receive information about specific recipients? The right to be forgotten is still on the table. There are questions about situations where is somebody a controller or not? The developer of a COVID tracing app who has been asked to develop the app and started testing it and putting it on the market without the person asking to develop it to do so. Is then the person asking to develop it controller or not? Those kind of questions. The position of the DPO will be next week. And then on supervision, I already mentioned the case on the Bundeskartellamt, but also there's a case presently pending about what if a DPA finds a breach of the GDPR, does it always have to then use one of its powers? Does it have to give a reprimand, an order, or does it have to do so, or can it also conclude it and do nothing? Is there a discretionary room there? And then, and that's the last theme I would say, and of course I can always go into more detail, but the last thing is national procedural rules. I already mentioned it in relation to Germany, but there are several member states who have a bit of a problem with the GDPR being quite silent on the articulation of, for instance, administrative enforcement, DPAs, and court proceedings. So we have a very nice case. It's an Hungarian case. It's C132/21, I guess, where somebody went to the DPA, and then the DPA did not say, it rejected the complaint, and then that person went in parallel to an administrative court to appeal against the DPA decision, and also went directly against the controller in a civil procedure, a damage claim. And that raises all kinds of questions. So is the civil court somehow bound by the DPA decision? Should the civil court wait perhaps for the administrative appeal? What if the civil court, which happened in this case, you can imagine which court asked the question, the administrative court, because the civil court already decided on the case. Is the administrative court then bound by the civil court? And if you look in the GDPR, you will not find the answer there. On the contrary, it says all without prejudice to the other remedies, etc. So then the Court of Justice asks, okay, give us guidance. And I think this is precisely, again, what we have been discussing as one of the themes these 2 days, is, how to solve this. Are we now all looking at the Court of Justice who will then tell what you have to do, or will it be pushed back to the member states, which as a consequence will have that, of course, there will be a lot of differences.
Thank you. Willem, on several occasions in the past, the court has issued decisions that touch on the powers and obligations, responsibilities of data protection authorities. There was Beltimo prior to GDPR. There was also, to a certain extent, Wirtschaftsakademie, Schleswig-Holstein. But you, in your former role as head of the Belgian Privacy Commission, you were involved in the Belgian Facebook case. Okay. So could you please give us maybe a quick overview of what the case was about, how it came about, and what are the main lessons learned?
Well, it all started in December of 2014, when we got a gathering of the working group 29, it was on that moment, and when we were confronted with new terms and conditions of Facebook, new terms of conditions who were there unilaterally. And our Dutch colleagues said it's impossible that it cannot be assessed fully by the Working Party 29. There was a little bit of tension because on that moment Facebook had his main establishment in Ireland, Dublin, and it was the Irish Data Protection Supervisor who in 2012 has made the whole inquiry and has found that all the processings of Facebook were great. It was okay. In 2012 already, there was a lot of tension in the Working Party 29, certainly because the German Data Protection Authority had a much more look better to the processings of Facebook and found some critical and difficult processings. But okay, 2012, we accepted the report of the Irish Data Protection Authority, accepted. It was not really approved, but we take notice of it, okay. But in 2015, in January, and as Belgian Data Protection Authority, we are very lucky because several universities worked together on social networks, and one of these parts of this inquiry was the legal one. And on that moment, we met Brendan Valsnoy, who was then a scholar at the University in Leuven, and he explained that there were a lot of difficulties. There was also a large inquiry by the Leuven and Brussels University on the processings, and we found out that, for example, with the help of the plugins, the pixels, and so on, cookies, that the behavior of all internet users, also of the people who didn't have an account on Facebook. There are people who don't have an account on Facebook, and that even these people, that their communication, that their way of behaving on the internet was followed by Facebook. So it looked to us very clear that it was an infringement of the data protection legislation. They made a whole report, about 120 pages, with 11 critical points, but we choose, as Belgian authority, one of these points, specifically this behavior following by Facebook. The Dutch has taken another one, the Germans also, the French CNIL has also worked together with the Spanish. That were the 5 data protection authorities involved in this, let us say, task force Facebook. We, as Belgium Data Protection Authority, we didn't have the power, the legal power to impose sanctions, so we had to go to the court. We firstly have some hearings with Facebook. Hearings is a very nice word, but it's very difficult to listen to evangelistic messages, but who had no really answer to that. Then we had made an inquiry. We had made a recommendation to Facebook, to the users of Facebook, because that's also very critical. The processors and the controllers who use products of Facebook, and also to the, let's say, the citizen. That were the 3 addressees of this recommendation. Facebook rejected also the results of the critical report, rejected also the recommendation. So we didn't have not other possibility than to go to the court. We started with an urgency procedure to get provisional measures. We were lucky because in October of 2015, we had a decision of the summary decision with provisions from the judge of the first instance, who is saying your processing of personal data on that point, on the following of users, is illegal. You had to stop it, and you had to stop this whole processing. Then we had a very difficult position because Facebook was of course not agree with this measure. They stopped also a lot of processing in Belgium. It gives us some critical and hostile reactions from the public because I will not go into details. Facebook is going to the Court of Appeal, and the Court of Appeal is saying we don't have jurisdiction for Facebook Ireland, we don't have jurisdiction for Facebook Inc., for Facebook Belgium, no problem, but we don't accept that there is urgency, because you was already aware of the fact that there were some problems in 2012. We were a little bit surprised because normally judges, when they are confronted with fundamental rights, accept very easily that there is an urgency, certainly for provisional actions. But in this case, they said, oh, no, there is no urgency. By the meanwhile, we had the procedure on the substance started in September 2015, and in February 2018, we get a ruling, a judgment of the first instance tribunal of Brussels here, who was giving full 100% reasoning to our claim, our litigation against Facebook, and who decided that their processing was illegal and that they had to destroy all the elements that they have gathered all these years before. Again, appeal, the Court of Appeal said again, we don't have jurisdiction for Inc., Facebook Inc., we don't have jurisdiction for Facebook Ireland. We can, because in the meanwhile there was the General Data Protection Regulation, and then they said we have to black out the whole history before the 25th of April, because we now know in a new area the General Data Protection Regulation. So there is now pending a case before the Court of Cassation in Belgium against this judgment of the Brussels Court of Appeal on two important points. And then the Court of Appeal has also asked a few questions at the Court of Justice in Luxembourg, and that is the coming out of this ruling. So we are still with this case before the Court of Cassation. What also there we will have a very difficult situation, because normally it is now up to the Court of Appeal of Brussels to handle the case against the Belgian branch of Facebook. And it is a little bit now the decision of what the Irish Data Protection Authority shall say. Shall they say, okay, that's your case, Belgium, go ahead? Or will they say, we use the one-stop shop mechanism and it's up to us to decide? And in the meanwhile, maybe the Court of Cassation will give reasoning to the Belgian Data Protection Authority, and then the court will, the case will refer to another Court of Appeal. So we are here in a very difficult judicial imbroglio, but 7 years of procedure.
And it's not the end of it.
It's not the end.
Despite the fact that I think the AG opinion in that case was issued about 18 months ago, and the ruling almost exactly 1 year ago, the Court of Justice. So it still continues at national level. I'm sure we will come back in a minute to, let's say, the lessons and discussion of some aspects of this specific case. But before that, I would like to shift the perspective a little bit and maybe introduce even more complexity into these discussions. So, Eva, from your perspective of the EEA and EFTA surveillance authorities.
Yes, first of all, thank you, Anna, and thank you to Wojciech and the DPS team for organizing such a wonderful conference. I have to say, I have the feeling like I'm, having a box of chocolate and having my play, and I have the feeling also I'm a bit like a black licorice in the middle of that box of chocolate. The EEA agreement is fairly well known, or should be fairly well known, because this is an agreement about European Economic Area that basically extends the internal market to Norway, Iceland, and Liechtenstein. And the objective of that agreement is to have a dynamic and homogeneous area of internal market that is based on common rules with adequate means of enforcement, including also at the judicial level. And with the view of obtaining that, the EEA agreement also has surveillance and court agreement, and on the basis of that, it has established the EFTA surveillance authority that basically plays the same roles against those three countries as the Commission against its member states, and also it has established the EFTA court that deals with the interpretation of the EEA agreement. And the way that the system works is that when EU adopts any act of legislation, that then goes to the EEA Joint Committee that consists of the ambassadors of those three states, the representatives of the Secretariat of the General Secretariat of the Commission, where the decision is taken whether a particular act will be made part of the EEA legal order and whether there are any adaptations that are necessary that come from constitutional requirements of those states, etc. So GDPR has been incorporated into EEA law by the Joint Committee decisions, and there are a number of adaptations that have been introduced. One of the most important adaptations is that that EDPB decisions are binding directly on the data protection authorities in those states. And why I'm saying that this is important, because normally within the EEA structure, the way that it works is that actually it's the EFTA surveillance authority that plays intermediary role, that you have the EU agency that takes some sort of decision that is directed towards member states, and then this decision is sort of readopted by the EFTA surveillance authority, and therefore it is enforceable against those member states. In the GDPR, this has been removed, so the two-pillar structure has changed into one-pillar structure. So the EDPB, for example, adopts a binding decision, and this decision is enforceable, or should be enforceable, against the data protection authorities in those three states. There are also a number of other adaptations, because data protection authorities from those three countries have full participation in the one-stop shop mechanism and also consistency mechanism. They have the same rights, they have the same obligations in the EDPB, apart from the right to vote on a decision. So it might be, we might have a situation where the DPAs from those countries will actually be concerned authorities. They might even be a lead authority in some occasions. They will not be able to vote on their own decision. They also don't have the power to stand in the elections to become the president or the chair or deputy chair of the EDPB. The other thing that has been removed is the Joint Committee decision has removed reference from in the GDPR to the Charter of Fundamental Rights, and it says that exercise of powers is subject to appropriate safeguards, including effective judicial remedy and due process. And that is because the Charter is not binding on the EEA states. They are not party to those instruments. But the effective judicial protection and the effective judicial remedy are known as general principles of EEA law and are enforceable in front of the EFTA court. The other differences that have been introduced is also that EFTA surveillance authority has the power to actually participate in the EDPB meetings. And we do have a representative who I know occasionally goes there. We also have, as an authority, we have the right to request advice and opinions and communicate matters to the EDPB in the consistency mechanism. We can request opinion on matters of general application, and we can also address EDPB where DPA does not request EDPB opinion or it doesn't follow EDPB opinions. So in all those instances where in those articles the Commission is mentioned, the EFTA Surveillance Authority is also mentioned. So the problems that come from having this sort of structure, as I have mentioned, we will have, for example, EDPB will issue a decision. This decision will be binding on the data protection authorities in those countries. The DPA will have to act in accordance with that. And let's say you want to challenge that decision in the national court. The way that it works, you will not have the power in Norway, Iceland, or Liechtenstein to actually use the preliminary ruling procedure in order to challenge the EDPB decision that was the basis of the DPA decision, because there is no reference to the European Court of Justice. We do have the EFTA Court, but the role of the EFTA Court is not to assess the validity of EEA legal acts as it stands. and definitely not to challenge the validity of the EDPB decisions. So one of the solutions that has been mentioned by some academics was the possibility to maybe use Protocol 34 of the EEA agreement. And it's a protocol that would allow national courts from those member states to ask preliminary questions, to ask for preliminary rulings from the European Court of Justice. However, in order to start that, you would need to have a declaration from the member states. If you would have that, then there is a danger that that would actually diminish the role of the EFTA court as such, because some courts might be more interested in going directly to the European Court of Justice instead of going to the EFTA court. Normally what happens is the national courts from those states request advisory opinions from the EFTA court on the interpretation of the EEA agreement and the secondary legislation that has been incorporated into the agreement. And that's how it works. Very often it will happen that you will have similar issues appearing at the same time before the Court of Justice and before the EFTA court. And the way that it is being dealt with is mainly through the principle of homogeneity, because it's a principle of homogeneous interpretation. So the EFTA court is supposed to interpret the rules of the EEA agreement and the secondary legislation in such a way as to ensure the homogeneous application of those rules on the national level. But going back to where we started, when you're a data subject and you have a decision of the Data Protection Authority that has been based on the EDPB decision, in those countries, you will not stand a chance, you will not have a possibility to actually challenge the validity through your own national court. So you will be, in a sense, dependent on, people in other countries, if there were other DPAs involved and decisions have been issued. And this issue, will it be raised? Will it not be raised? Yeah.
As if things were not yet complicated or complex enough. Yeah. Thank you.
That's why I'm leaving out the adequacy decisions.
Maybe in the next round. Herwig, so you have been involved in litigation in many cases. You have also worked in academia on administrative law, on composite procedures. Can you tell us more about your views on the Facebook Belgium case on the one hand, and maybe broader lessons to be drawn from the Court of Justice case law?
Yes,
Please.
thank you very much.
No worries. Yeah. Should be closer?
Left.
Maybe it helps to just take off the little machine here and put it here.
Is it now better?
Yeah.
Now it works, okay. The little machine does the job. Good. Well, thank you very much, Anna, for this invitation and the possibility to talk a little about these matters. So, 4 years of experience with the GDPR is, in a way, a little too early to draw a conclusion, but also looking at the amount of case law which has come out and the amount of cases pending, we see clear trends of problems and of issues. And of course, the entire conference has been very fruitful discussing possible ways out, and I'm looking forward to discussing that a bit more in our discussion today. If you want to summarize the Belgian Facebook case, and of course, I'm not very friendly to it, it essentially says, come on kids, play together nicely. Everyone has to cooperate. But when you look at the big issues we see coming out of litigation which is currently pending, and what the frictions are, we see 3 big areas of problems. We see the one huge field, and that's where Belgian Facebook case was playing, the difficulties of these composite procedures, the difficulties of the structure which the GDPR set up to have multi-jurisdictional cooperation from competent authorities, from lead authorities, from the European Data Protection Board. And the questions which arise, which have been discussed also yesterday and today, are very much, do we need to actually change the interaction here would we need to have a possibility of a lead authority also on the European level? And these interactions, of course, are very, very complex, not just because we have so many actors from various jurisdictions involved, but also we have so many forms of act. We have guidelines and we have decisions integrated into a final decision, sometimes clearly, sometimes less clearly. This is what makes for great difficulty in understanding of who is contributing how and who is responsible at the end of the day for some mistakes. And Advocate General Bobek was already cited. You know, if you have a diffusion of competencies and responsibilities, you have essentially at the end of the day, very little of that. And a judicial review is, of course, always about first identifying responsibility in order to be able to address remedies. Now, a second big area, which is unclear and which is hugely problematic, is exactly this interaction between public and private enforcement. We have several cases at the Court of Justice currently trying to establish what is the level of damages you must have suffered in order to be able to bring a damage case. But as Herke was mentioning, the question of relation between public and private enforcement, what does it mean if there is a parallelism? Does it work like in competition law, or do we have specificities in the data protection field, are all highly relevant matters. And the third big area, and that I hate to say is still the issue of international transfer of data, because this complicates to a certain degree the already very complex composite structure, because not only are we having various jurisdictions of the EU and of the EEA involved, but also third jurisdictions. Just to remind you, the initial Schrems complaint, which led to Schrems 1 and the other cases, is not resolved. We don't even have a DPC final decision yet. And that, I think, should be enough to show that there is something fundamentally problematic in our setup. And a lot of the discussion of how to deal with this is exactly there. And let me say, this is not just a problem for complainants, individual complainants, who raise a complaint with a competent authority, who then see their complaint be dealt with by a lead authority somewhere else, who have no longer rights as party to a procedure, have difficulties of access to documents. It's also a big issue for small and medium-sized companies, as we were talking about yesterday and today in various sessions, because they see that big players, the big players, we all know them, the five, are getting away with a lot, and smaller and medium-sized companies have a disadvantage in establishing their position on the market because they play by much more strictly enforced rules. And this is exactly an issue we need to address in this context. And just one last point, in a way, also structuring the debate, we are now confronted with a host of new legislative proposals by the Commission, AI Act, Data Act, and so on and so on. And we see that a lot of the problems we've encountered in the GDPR, in the first 4 years of GDPR, which were, of course, not surprising for anyone who had studied composite procedures earlier. It was quite clear that this was going to be a very, very complex and messy procedure, that we have a lot of these issues being now replicated in the other legislative proposals, and that therefore addressing these issues in a somewhat more coherent way might be a very good idea.
Thank you very much. I think one point which is maybe obvious to practitioners but often escapes the broader public or us observers is maybe this timeline question. So we oftentimes have the impression that, okay, now the Court of Justice has decided, has spoken, so we have clarity. But actually what comes out quite clearly, this is far from it. There still a lot has to happen at national level, and it can also take time, and actually we don't necessarily then follow up to the end to know what was decided eventually when and how it played out at national level. So this is certainly something to keep in mind as well. I don't know where to start. So many different issues that we, would merit a separate discussion, already touched upon here today. But maybe going back to the courts quickly before we leave system sometimes for questions. Going back to the Belgian Facebook case and this vision of the court, which I think also the judge rapporteur at some point described as the one-stop shop only being a network of supervisory authorities, with the lead authority playing this role of a hub, but being an integral part of, collaborative structure with the spirit of sincere cooperation. It seems to me that this is a very nice vision, and that both the Advocate General also agreed that this is what is in the GDPR and its preamble, and what was the intention of the legislator. But does this really reflect reality, or what needs to happen to make it reality? And are maybe some of the other pending cases of the court hopefully offering some ideas?
If I may very briefly because I didn't comment on the Facebook Belgium case as such, because you said you are not very friendly towards the ruling, right? That's what you said? Yeah. So normally I defend the Commission, but now I would want to defend the courts for once. Now, I think what we should not forget is what the case was about, as Willem very well explained. It was not about whether or not the one-stop shop mechanism functions, whether the deadlines, whatever. It was not about that. What was at stake was actually the one-stop shop mechanism as such. Because what was happening is that Willem's DPA was actually in court, while in theory this should be a situation which should be dealt with in the one-stop shop mechanism by the lead supervisory authority, being the Irish DPC. Apart from that, it didn't happen, and the history you explained. And the big question was, because the GDPR is a bit silent on how the competence of a DPA to go to court, to the national court, how that actually is or is not curtailed by the one-stop shop mechanism. The GDPR doesn't say anything about it. So the discussion was, again, it was not about the functioning of the one-stop shop mechanism. It was whether a DPA should still be entitled, despite the administrative structure of cooperation, to go to a national court. And that is what was discussed. Also during the hearing, there were concerns from the judges, including the president, that this is actually limiting a very important power of the DPA, which it has at its disposal to protect fundamental rights. So can the GDPR like that do it? And if you then look, from that perspective, if you then look at the court ruling, it's a wonderful ruling, because they fully go for it. They really go for the European approach here. They really follow all the steps. They explain the whole system as it should work. And I'm the first to say, we should of course see how it works in practice, but in particular in relation to this ruling, I think the court actually saved the one-stop shop mechanism, being aware, also thanks to Mr. Bobek, who explained that very well in his opinion, being aware that we still have to see whether it will function. And Bobek literally said we have to give the infant the benefit of the doubt, and that's exactly what we're discussing at the moment. But the court was aware that the whole thing stands and falls on the responsibility, and that's for me paragraph 68 of the ruling is the crucial message from the court. We have explained the whole system, we have kept it, but you have to assume your responsibility, in particular if you are the lead supervisory authority. It's almost a political message. And of course we can then discuss whether the system as such is good, maybe not, and whether repetitions in other legislation which are not exactly copying it but with different, whether that's a good idea, that's another story. But I think the judgment as such is certainly to be applauded.
The problem arising, if I may follow up on that, is what happens if this sincere cooperation, which is built on goodwill, either for procedural reasons in the member state of the lead authority or of political pressure, doesn't work the way it should work. The huge amount of procedural discretion which the lead authority has, for example, to open up own volition inquiries next to procedures where a complaint had come in, to pause certain procedures, to, after having received EDPB guidelines, to pause things and to wait. All those accumulated procedural possibilities of a lead authority can lead to a de facto slowing down and near impossibility of enforcement. And if you think of the timelines of the cases we're talking about, the Facebook Belgium case, the Schrems cases and so on, and the timeline of the existence of the internet as we know it, and the speed of the evolution of the internet economy, I think we are facing a fundamental problem that a cooperation mechanism, which is built on a lot of goodwill, but hugely slowly working cooperative structures, might not be absolutely up to speed. And after 4 years, it's time to consider, yes, it's young, but what can we do better?
Willem, please.
Well, I think that the case the court has given a very strong message also, not only to the lead supervisory authority in saying you are not the solo slim, you have a very important role, but also the concerned authorities, they have the power, they have the possibility to insist to get a very much more quicker and swifter advance in handling this case. And I think that it's very important to stress that out. 78, but also 71, where the court is saying you have also an urgency procedure. Use this urgency procedure when you see that the lead authority don't do his or her work. So it's the court who is saying, get up, wake up, and you as every concerned authority, you have also your possibilities, you have also your responsibility. And that is, I think, a little bit a new message or a new inspiration for a lot of authorities who are a little bit paralyzed by the fact that when you have a lead authority who is inactive or who give no communication, and we have had the experience that you have such authorities, on that moment you are practically inoperational. But the court said, no, you can act. You can use, for example, 61.8, you can use 65, you can use 66 urgency procedure. So the great problem now is the gap between the theoretical framework has been also enlightened by the court and the reality. There is a very gap between the reality and what it should be. Sein und sollen, there is a big difference on that.
But it is,
I hope with the Vienna statement that we are now going into a new area where they really make this cooperation much more effective.
Yeah. I believe this morning we heard from Ms. Marie-Laure Denis from the CNIL that they want to demystify a little bit both 65 and 66 procedures and treat them as normal tool of cooperation and not go against the perception that if these tools are being used, that somehow signifies the failure of cooperation. No, they are there in the regulation for a reason and should be used. So indeed, we will have to see how that plays out. But I wanted to zoom in on one particular aspect that maybe didn't necessarily come out of this discussion specifically, but was, pervasive in other talks earlier today and yesterday. That this harmonization of procedural rules and the subtext. The lead authority maybe should have deadlines. Maybe there should be, for a DPA, an obligation to always issue decisions in every case. Every complaint needs to have a clear outcome. I think, Eva, you had some experience with firsthand how that might lead to intended or unintended consequences in practice?
Definitely, one of the very first cases that came up before the EFTA, well, the only data protection case that came up before the EFTA court, it was joint cases 11 and 12 by 19 at publisher. By the way, if you're ever interested in watching the hearings before the EFTA court, they are streamed online, and the written observations of the parties are posted online also after the judgment is delivered. So just a plug for the EFTA court. This case was actually really, really interesting because it originated with the Liechtenstein Data Protection Authority receiving a number of complaints about practices of a certain company. And they started issuing decisions against the company. It was about receiving unwanted mail and where did they get the data of the person from. So in accordance with the Liechtenstein law, once you file a complaint with the DPA, you have the right to obtain a decision. So the DPA started issuing the decisions to all those people who started complaining about exactly the same case against exactly the same company. I think there were about 20 such cases that were pending. Of course, the company was not very happy about it because then they had to challenge the decisions of the DPA before the national courts. And suddenly what happened is that in accordance with the procedural rules, since the complainant was party to that decision, they were suddenly liable for costs in the case where the controller challenges the decision of the DPA. So, it is not nice for the complainant because suddenly he faces the legal charges of the controller, and it must have not been really nice also to the controller where he had to go and challenge 20 or 30 cases on exactly the same thing, exactly the same processing. The only difference was the different people who were part of it. Another interesting part of that case was also that when they've made a complaint, in some cases the DPA followed and sort of stuck to what was the scope of the complaint, but in some of the cases, the final decision of the DPA was actually broader than what the complaint was. They have noticed certain things that the complainants didn't include in their original complaint. So there were two issues that came before the EFTA court. One of the issue was the disclosure of complainants' personal data during proceedings before the national court. The reason why the controller wanted the disclosure of the data was because they wanted to know to whom they can go and demand the money for their legal costs. And so that was one issue, so the disclosure of data, and then the second issue was actual costs that can you demand it from those people. And the EFTA court actually decided that the disclosure of complainants' personal data during proceedings is not precluded by the regulation or any other provision of EEA law. And the question to non-disclose the data of the complainant must every single time be examined in light of the processing of personal data on the basis of Article 5 and 6. They have made reference to effective judicial protection and the right to fair trial, and they said, well, if you want to have effective judicial protection, that is a general principle of EEA law, you have to have a right to mount an effective defense. Sometimes, in order to mount that effective defense, you will have to know the data of the person. But if it is just a general case like that, what do you do? And I will go back to what the national court had done there. The second issue was the question of costs. We had a situation where somebody made a complaint and suddenly became party to the proceedings before the national court in accordance with the national procedural rules. And the EFTA court decided that, on the basis of the GDPR, the person cannot be made responsible for any costs that are incurred in relation to those proceedings. And that was a really interesting thing, because when you look at Article 57.3 of the GDPR, that is the only place where the costs are being mentioned. And that is, what is happening before the DPA. In Article 77, you don't have anything of that kind. In Article 78, you don't have anything of that kind. In the national law, yes, the proceedings before the DPA were free, but then in the civil court you actually had, and the administrative court, you had to bear the costs. And the court actually underlined that under the principle of procedural autonomy, the implementation of the judicial remedy is left to the national legal order, provided that principles of equivalence and effectiveness are respected. And that should sound a bell, because this has been I will not say echoed because, but it has appeared recently also in the Court of Justice case law on the consumer protection, where the court has actually referred to the principles of equivalence and effectiveness. But when you look at the reasoning of the EFTA court added that obligation to reimburse costs is not in line with the right to complaint, to lodge a complaint free of charge under Article 77 and 57 of GDPR, and moreover runs contrary to the purpose of GDPR to create a strong enforcement mechanism and enhance legal and practical certainty for the data subjects. The prospects of cost reimbursement constitutes a disincentive to lodge a complaint before a supervisory authority, so the court found that such a setup undermines the scope of protection guaranteed by the provisions of the GDPR and the exercise that are of rights confirmed by EEA law. Would be rendered excessively difficult, and that would be in breach of the provisions of the GDPR. That is actually going quite far. You know, they left it to the national court to use any powers that they have of interpretation under the national rules, but they said you have to interpret those rules in such a way that it will not impede the effectiveness of the GDPR. And we've actually followed up on that case. We wanted to know what has happened. And it went 2 more rounds in the national the national system, and it was very interesting because the court of the lower instance actually relied on the effective judicial protection and demanded disclosure of the data. The Court of Appeal then said, you know, you cannot just quote one paragraph of the judgment and demand effective judicial protection. You have to make assessment on the basis of Article 5 and 6. And then they have proceeded to actually analyze the whole structure of who is the complainant, who plays what role in the proceedings, in order to decide the case on the costs. So I think that there is actually, maybe it is not as evident from the cases that we have before the court, but I think that there is a lot of space to influence the procedural rules in the member states on the basis of those arguments, and that might actually contribute to increasing to better enforcement. You know, we all have heard the story of how much legal costs Max Schrems was supposed to bear in Ireland, right? And what I find interesting in this particular case is that you see that sometimes it's not the DPA who, oh, I don't want to do something. And it's like, no, they're usually acting in good faith on the basis of what their procedural law is telling them to do. Like, you know, I have to do something within this time or that time, or somebody says, I don't have a deadline, you know, I'm going to need more time. So a lot of problems in cooperation between the DPAs within even the one-stop shop, I think, stem from those procedural differences. And those differences not really on the basis of do we have procedures within the GDPR that concern the one-stop shop and how it is organized, but lower down.
But thank you. I think it could be relevant to also the discussions about the, position of the complainant in the procedure by default, involved as a party or not necessarily. I don't believe we have pending cases about this specific aspect now before the Court of Justice, but maybe they will come at some point as well.
Whether an individual...
No, the cost, for example, and whether this is impediment to access to justice. But anyway, we have, I'm afraid, come to the end of our allotted time, but I hope we still have a bit of, well, not surprises, no surprises here, a bit of time for a few questions. There are two gentlemen over there. If you could introduce yourself and please ask your questions.
Hi, my name is Fergal Crean. I'm a GPO with 3 Ireland Telecoms. There was a reference to a couple of cases on kind of private enforcement and the consideration of damages and a threshold for damages. I was wondering, could we hear perhaps briefly about those?
Thank you. Shall we take the other question maybe first and then whoever?
I'm Heiko Dünkel, Head of Litigation Department of German Consumer Organization, Federation of German Consumer Organization. We have our own Facebook cases, some before the EU CG, but we are also third party in this case of the German Cartel Office. And in both areas, we are confronted by Facebook by the arguments we heard here. No jurisdiction, you have no legal standing, you are intervening in the one-stop shop system of the DPAs. Do you think this is a problem, or should both areas be learned from each other? Because with private enforcement, there is a effective way to enforce GDPR without DPA confusions among different areas.
Thank you. Who wants to go first, gentlemen?
As you wish.
Go ahead, I'll follow you.
Okay, so very briefly, because we don't have much time, and I want to give you the floor as well. So to pick up on the last one first, so and I also to react a little bit to what Herwig just said, I do agree that maybe the GDPR was written for a system that functions. There are some elements, of course, for when it doesn't function. That's why the board can kick in, if there's disagreement about who's the lead authority, that kind of stuff. But the inaction of a DPA, or if it takes too long, that has not been addressed. And I think that's something which indeed is if ever we open up Pandora's box, this is something that could be included if we are not aiming for a completely different enforcement structure. And you asked about, are there any relevant pending cases? Well, precisely this German case on the Bundeskartellamt is relevant because the Bundeskartellamt, the competition authority, was also confronted with the DPAs not, well, the German DPA was very cooperative, but there was, of course, in principle, that was also an issue of one-stop shop mechanism where they should consult, etc. And the Bundeskartellamt, and you must imagine, they are competition, big money, fines, big machine, wondering whether they would have to wait for those little small DPAs to come up in their messy system with an opinion which they have to or don't have to take into account. So, but that ruling might certainly give some input for what if there's inaction. And on the damages, but that maybe you can also take, there are several cases on damages. It's linked to the national procedural autonomy. As I said already, the GDPR does not harmonize anything on national procedural law in that respect. 77, 78, 79, 82 on compensation for damage, there's no harmonization. So then you end up with exactly what the EFTA court has done, the principles of effectiveness and equivalence. Because there is space for a national law there. But it has to respect those two principles. Well, the big question will be, how far will the Court of Justice go under those principles in saying how it should be? My guess is that they would rather say the situation we have in front of us is okay or is not okay. But of course, they are not going to proactively create, let's say, the harmonization of procedural rules. But
yes, thank you. Well, one of the issues of the damages cases and private enforcement therewith is inequality between member states, how rules are interpreted at the moment. Do you need a certain threshold of damages which you can prove, especially non-material damage is very difficult. Do you have to be upset or very upset or extremely upset about your data having been used, or do you have to show some kind of other damage, which in rules of proof would be extremely difficult, but some disadvantage appeared to you because there was a data illegally transferred or something alike. So those things are clearly problematic when it comes to the possibility of private enforcement next to public enforcement. With the evident difficulty of the public enforcement, and that was the other point of the role of the complainant, one of the things which the GDPR did was, and I'm not privy to the discussions in the negotiation, but knowingly or unknowingly, the complainant was put aside into an informant role, if I can simplify it. And actually, it's interesting, we've had other policy areas of the EU where that happened. State aids, for example, where complainants used to have an important role and were more and more marginalized to the role of simply an information giver. And that's understandable if you have a very complex administrative procedure between various authorities. They try to set that up, and then the complainant's rights aren't that involved. But this is a problem. This is a problem because often you have the individual who has to have a motivation to go and have a procedure where they can have access to documents, where they can see what's going on, and where they can necessarily, if need be, at the end of the day, go to court and defend their rights. So, and that's why I think this discussion about a more general procedural rule which could address many of those things, which don't necessarily have to be placed only in the GDPR. There are many aspects of initiation, rules on initiation of procedures, of procedural steps, of information gathering during a procedure, hearing rights, and so on. Rules of reasoning of decisions, which in multi-level procedures is always very difficult. You know, who reasons, for example, what happens if the Irish DPC at the end of the day doesn't agree with the EDPB guideline or decision, places it in its decision, says, this is what the EDPB asked us to say, we don't agree, but here it is, and has a decision which is incoherent at the end. What would a national court be able to do with it? All these things are very complex and messy in the moment, and there is really a lot of space for clear allocation of responsibilities as the discussion seems to be kicking off.
Thank you. I think we are way into the coffee break now, so if you don't mind, I would propose that any other questions are addressed during the coffee break. Please mark your calendars for the upcoming Court of Justice decisions. Please watch the court's calendar online, and also I think at least some of the hearings are also web streamed now.
Yes. Some of the Grand Chamber.
Some of the
in
Grand
principle, the
Chamber,
Grand Chamber.
yes, but you have to watch them, I think, on the day. Yes, they are not videotaped for watching later. So thank you very much. Apologies for running over time. And thank you to our panelists.